Hello everyone, welcome to PW OnlyIAS YouTube channel. And yes, today we will be discussing Fundamental Rights Part 1. Because it's a very lengthy chapter, we'll be doing it in two parts. Alright people, so without any further delay, taking you to my Telegram channel. Here you can contact me, ask your queries and any doubts that you have, that also you can ask. Plus on top of it, you can also send your previous year questions from 2013 onwards in this channel. All right. So let us take fundamental rights introduction. So fundamental rights, when we talk about which part of the constitution it is basically part 3 of the constitution, article 12 to article 35, inspired from the Bill of Rights in USA. All right, something similar to that. That is, it guarantees a certain set of rights to the citizens of a country. It's very fundamental for the survival of a citizen. All right, number one. Number two, why do you need this fundamental right? What is the purpose, other purpose behind it, other than the fact that it is so essential for a citizen? Fundamental rights is basically necessary to put a stop to any executive or legislative excess. Executive or legislative excess. Excess means what? Excess means doing something more than what you're supposed to be doing. That means if the legislature passes a law which violates the fundamental rights, or if the executive passes a law or does something which violates again the fundamental rights, both of this can be struck down by the Supreme Court. As simple as that. Now, very recently, Supreme Court has ruled what? That the property cannot be simply taken by the union in the name of common good. That is, your property cannot be grabbed by the government saying that it is for the greater good or for the community's good. It's a very important ruling and its repercussions we will have to watch in the coming days. Clear, people? So let us see. It's known as Magna Carta. Why? The Charter of Rights issued by King John of England in 1215 under pressure from barons. First document relating to fundamental rights of citizens. So Magna Carta means the most important document. And its foundation, if you see, its early history, if you see, can be traced back again to King John of England in the year 1215. All right. Now, fundamental rights are basically justiciable, uphold equality of all individuals, dignity of the individual, the larger public interest, and unity of the nation. Ensuring equality, dignity, public interest, and unity of the nation. For all this, you need what? Fundamental rights. For promoting political democracy, limitations on tyranny of the executive, government of laws and not of men. Political democracy, when we say, what we are trying to tell here is that everybody in the country are entitled to the fundamental rights. There is no difference between any individuals here. There is no difference. On the basis of caste, creed, color, sex, etc., you cannot actually give some people more fundamental rights and some people less fundamental rights. You cannot do that. Everybody are having the same set of fundamental rights. Number one. Number two, limitations on the tyranny of the executive. That is, government cannot simply do whatever they want. That is the entire purpose of fundamental right. To put a stop to the government. To tell the government what can you do and what you cannot. It's government of laws and not of men. Government of laws and not of men means what? Government of the country is bound by laws. Whoever is the prime minister, whichever is the political party, they all will have to do what? They will all have to follow the laws of the land. Just because X became the prime minister, he or she cannot do whatever they want. Or tomorrow the prime minister changes, Y became the prime minister, then Y can do whatever they want. No. Be it X, be it Y, be it Z, be it any political party, ABC, doesn't matter. All of them are bound by the laws of the country. Clear? For all-round development, material, intellectual, moral, and spiritual fundamental rights are required. That is, for the material, intellectual, moral, and spiritual development of the citizens of the country, fundamental rights are required. Clear, people? Moving on. It's guaranteed and protected by the Constitution. It is the fundamental law of the land. Now, original Constitution had the following fundamental rights: right to equality, Article 14 to 18, right to freedom, Article 19 to 22, right against exploitation, Articles 23 and 24, right to freedom of religion, Article 25 to 28, cultural and educational rights, Article 29 to 30. Now, right to property, which was under Article 31, has been deleted by the 44th Constitutional Amendment, and today it is only a legal right under Article 300A Part 12. What do you mean by a legal right and a fundamental right? Legal right means by law it is defined. It is not by law you have a right to property. Law is there. By law again that property can be taken away. Again, let me take you to a Supreme Court ruling very recently. That Supreme Court, again, because of the demolitions that were happening in UP, Supreme Court basically asked, now some of these demolitions were said that they were illegal. Notice was not given at the right time. Only a short duration was given between the notice and between the demolition. Supreme Court came down on it heavily and awarded 25 lakh in compensation. Means why? If the government is taking away my property also, it should be on the basis of what? Law only. Only through lawful means my property can be taken over. Only through the lawful means I can transfer it to somebody. Getting the point here? So, if the government is justified in seizing my property, it can be taken away. Can be taken away. As per proper law, proper steps, proper procedure, if it is done, it can be taken away. But none of these fundamental rights can be taken away like that. Again, that's very fundamental. I can, if any one of these fundamental rights of mine is violated, I can directly approach the High Court and the Supreme Court. That comes as the seventh fundamental. That is right to constitutional remedy, Article 32. Now I know Article 32 means you can directly approach the Supreme Court when your fundamental rights are violated. But there is again a Supreme Court ruling for this. Where relief is available through the High Court, you will first go to the High Court. Simple. That means under Article 226, if your fundamental right is violated, let us say, you will basically approach the High Court first. Because that is the general point. If relief is available through the High Court, please go there first, then come to us. Alright. Moving on. Features of fundamental rights. First feature is there is difference in the availability. That is, for citizens, aliens, foreigners, there is a differentiation. It is not that everybody will get the fundamental right. No. There is a difference between citizens, aliens, and foreigners. It is not absolute, but it is qualified. Means what? It does not mean that 24/7, 365, for all the years to come, fundamental rights will be guaranteed to you. There are certain restrictions placed on it. Reasonable restrictions can be placed. It is a balance between rights of the individual and society as a whole. It is about individual liberty and balancing it with social control. So, right to freedom, right to move anywhere throughout the territory of India. So, I have that fundamental right, right to move throughout the territory of India, comes under Article 19. Now, to move freely anywhere in India, does it mean I can simply walk into Andaman and Nicobar Islands where the Jarawa tribes are there in certain remote locations? Can I just go there, walk in there because I have fundamental right? No. Restrictions are placed. Restrictions are again placed when it comes to owning property in those areas which are mentioned in the 5th schedule or 6th schedule of the Constitution. Getting the point here? So that is what you mean by reasonable restrictions. Then it is available against arbitrary action of the state and of private individual. Arbitrary action. This is what I told you. State is taking away any fundamental right as per law, as per procedure, no issues. Simply out of the blue, state decides to pass some law which doesn't make any sense. Then Supreme Court will act on it. Plus, even against individuals, it can be passed. How so? So generally, what happens is, let us say my friend is missing, but I know very well that his parents have locked him up in the home because he has a love affair, etc. Now, can I go to the police station telling that he is missing? Yes, I can file a missing complaint. But police, again, they may try search here and there, and they may say that, okay, we have no evidence, etc. for it. But I strongly suspect he is locked up in his home. What can I do? I can go and file a habeas corpus petition in the High Court. I can go and file it. I can say that, I can basically file a petition telling that my friend is detained illegally against his fundamental rights by his own parents in their home. Then obviously court will direct his parents to produce him before the court. Getting the point here? That is what you mean by against private individuals also it is there. That is, even if private individuals take away your fundamental rights or does something which will affect your fundamental rights, then automatically you can seek relief. Some place limitations while others confer privileges. Some are about limitations, that is, it asks you not to do something. Alright, some on the other hand gives you privileges. It is justiciable, you can appeal to High Court and Supreme Court, it is not sacrosanct, can be amended by the Parliament without affecting the basic structure. That is, fundamental rights also can be amended, but it shouldn't affect the basic structure. Basically, it simply means what? Don't touch it. I can add a word, I can maybe add 2-3 words, or maybe remove 1 or 2 words, change the meaning, etc., without compromising the basic structure. But I cannot take it out. Clear? Moving ahead. Can be superseded during national emergency except Article 20 and Article 21. That is, one is arrest. With regard to arrest, one fundamental right. The other fundamental right, Article 21, is about what? Right to life. So when national emergency is in place, all the fundamental rights are suspended except Article 20 and Article 21. 6 rights under Article 19 suspended only for war and external aggression, not armed rebellion. So the 6 rights, that is, right to move throughout anywhere in India, right to reside anywhere, practice profession, form association, gather, those rights are only suspended during war and external aggression, not during armed rebellion. Scope of operation is limited by Article 31A, saving of laws providing for acquisition of estates, Article 31B, validation of certain acts and regulation included in the 9th schedule, and Article 31C, saving of laws giving effect to certain DPSP. That means what? 31A, 31B, 31C. If any law is passed which comes under 31A, 31B or 31C, it doesn't matter if fundamental rights are getting affected. 31A is about what? Acquisition of estates. That is the land reforms, basically. Acquiring estates. So I cannot go and say that, look at this, my land is being taken away by the government. My fundamental right is getting violated. No. 31B, validation of certain acts and regulations included in the 9th schedule. 9th schedule, we know already that 9th schedule purpose is what? It is to basically protect certain acts from judicial review. So even if the fundamental right is getting violated, but the act is placed under 9th schedule, means nothing doing. Number 3, 31C, saving of laws giving effect to certain DPSP. This is what I told you. That is, DPSP means what? Directive principles of state policy. Now, one of the directive principles of state policy is what? Basically, to discourage the sale of liquor. Correct? Now, to give purpose to that, give effect to it, if the government passes a law, nothing can be done. You cannot go and say that it is my fundamental right to live how I want, to run what business I want, because right to profession guaranteed under Article 19. So I cannot say that this is my wish that I want to run a pub. Why are you coming and stopping it? Because it's a principle under DPSP. Application, again, let me tell you, it will all depend from case to case basis and how Supreme Court is interpreting. Clear? As of now, this is what it is. Scope of operation is limited when you say always fundamental right will not have an upper hand. If it comes under Article 31A, 31B, 31C, acquisition of estates, 9th schedule, DPSP, fundamental rights applicability, the scope of it is limited. Clear? Application to armed forces, intelligence, etc. can be limited by Parliament under Article 33. Means what? See, these days at least we don't see that much. But a few years back, you would have seen many armed, that is, people within the armed forces, especially the military and all, shooting a video and telling, listen, we are not having this facility here, that facility here, this is not there, that is not there. You're not supposed to do that. Even as a civil servant, once you become a civil servant, let me tell you, you cannot actually go to the media and start making statements until and unless your senior tells you or designates you that, okay, go to the media, brief the media. Going to the media, even I have seen many students, sometimes when they write their ethics answers also, they will write there, I will go to the media and report everything there. No. You can report to your senior. Your senior doesn't agree. Your senior is an unethical person. You can go above that. His senior, you'll follow the protocol. You can go to the court. Media is the last place that you will go to. Getting the point? So, armed forces, again, they have restrictions. Once you're part of the service, you cannot simply blabber out everything and anything that you want in the name of what? Right to freedom of speech and expression. Application can be restricted when martial law is in place. That is, military law is in place under Article 34. Laws to give effect to certain fundamental rights can be made only by Parliament. That is Article 35. Most FR are self-enforceable. That is, ultimately, who has the powers to pass any law to give effect to fundamental right? That is again the Parliament. So understand, citizenship chapter also I told you, ultimately it is Parliament's discretion. Similarly, when it comes to fundamental rights also, it is up to the Parliament to pass laws to give effect to any fundamental right. However, most fundamental rights are what? Self-enforceable. All right. Fundamental rights that are not available to foreigners. Very quickly, 15, 16, 19, 29, 30. That's the number. 15 is what? Prohibition of discrimination. That means I can discriminate against a foreigner. I can discriminate. You're not an Indian, you're a foreigner. Go. I can do that. So foreigner does not have access to what? Article 15. Then Article 16. Equality of opportunity in matters of public employment. Obviously, a foreigner comes tomorrow from USA. He's a US citizen. And he says, even I want to prepare for the UPSC. You cannot allow him to do that. He's not an Indian citizen. So Article 15 is not there. Article 16 is also not there. Then comes Article 19. The 6 rights guaranteed under Article 19. That is, right to move throughout the territory of India, practice any profession that they want. Residents, they don't get access to that also. Restrictions are placed. Then, protection of language, script and other culture of minorities. Article 29. Foreigners cannot claim that they are a minority in this country. So they will start institutions here to protect their culture, their script, etc. They cannot claim it. Right of minorities to establish and administer educational institutions. Even that won't be allowed. Clear? So 15, 16, 19, 29, 30. Discriminated. They don't get access to public employment. 6 rights under Article 19 is suspended. Then language and script protection plus running educational institutions. Clear, people? Moving on. Definition of state. Now, when you keep on telling that fundamental rights is to put a check on the exigencies that could be committed by the state, what comes under the meaning of state? Let us see that. So, Article 12 has defined state for part 3, that is fundamental right, as executive and legislative organs of the union government, executive and legislative organs of the state government, local authorities, that includes panchayats and municipalities, statutory and non-statutory authorities, that is any body set up by law or maybe even set up by an executive resolution. Even a private body working as an instrument falls within the meaning of state under Article 12 as an instrument of government. That means everything will come here under the definition of state. It could be the parliament, it could be the legislative assembly, it could be the central government, it could be the state government, it could be a local government, it could be a PSU, it could be something like, let us say, RBI, anything it can be. Any body that is associated with government, even a private body that is doing the work of the government, will also fall under the definition of state under Article 12. Clear, people? Moving on. So, laws that are inconsistent with fundamental rights, what will you do? I already told you the answer for this. This is basically looked after by the Supreme Court and the High Court. If your law is violated, if your fundamental right is violated, you can easily go over, you can easily approach the High Court, if necessary, even the Supreme Court, under Article 32 and Article 226. 32 for Supreme Court, 226 for the High Court. Clear? And which article provides for this ability of the judiciary to actually analyze and see whether the laws are consistent or not? That is actually provided by Article 13, which provides for judicial review. Clear, people? And what type of laws comes under it? Any law enacted by the parliament or state legislature, ordinance passed by the governor or the president or any temporary law, delegated legislation like rules, bylaws, regulation, etc. That is, even if you pass a law like an executive order or which violates the fundamental rights of a citizen, that also you can take it up to the High Court or Supreme Court. Custom or usage having the force of law. That is, again, any order. Article 13, constitutional amendment, not a law, hence cannot be challenged, but this was changed by Supreme Court in 𝐾𝐶𝐿 Bharati case 1973. Basic structure means what? Earlier it was ruled that constitutional amendment is not a law. Earlier Supreme Court had made a ruling that constitutional amendment is not a law and therefore does not fall under the purview of Article 13. That means any amendment that you make, that even if it violates the fundamental right, it is okay. That is what initially Supreme Court ruled. But the same Supreme Court reversed its stance when in the case of 𝐾𝐶𝐿 Bharati case 1973, where they said that even constitutional amendment will come under the purview or the limits of the Supreme Court under judicial review of Article 13. Why? Basic structure doctrine they brought in. That means amendment you make, any amendment you want you can make, but it should not violate the basic structure of the Constitution. Basic structure of the Constitution has not been defined by the Supreme Court. Today a general idea is there, what is the basic structure? Okay, these things will come under basic structure. A general idea is there based on multiple Supreme Court rulings, which again we will be seeing in our coming chapters. Clear, people? Moving on. Now let us start to see each fundamental right one by one, starting with right to equality. So right to equality, when we say Article 14, equality before law or equal protection of the laws to any person. Equality before the law, that means all are equal before the law. Equal protection of the laws to any person. Everybody will be protected using the same laws, which is borrowed from American Constitution. Let us see. Equality before law, it's a negative concept. Why negative concept? Because it talks about absence of special privileges. Nobody is going to be considered special. One rule for the king, another rule for the subjects, nothing doing. Everybody will be under the same law. Equal subjection of all persons to the ordinary laws of the land administered by the law courts. Through courts, whatever laws are being administered, everybody will be subjected to the same law. No special consideration. And nobody is above the law. So that is why it is a negative concept. Basically, it is trying to tell you are not special and all. You are also under the same law just like me. That is what it simply means. Equality before the law. Ambani, laws for the Ambani, laws for me, laws for you, all are the same. Equal protection of the law. Positive concept. Equality of treatment under equal circumstances. Same treatment for everyone. Similar application of the same laws. That is, if Article 19 is there for me, Article 19 is there for you also. Like should be treated alike without any discrimination. Like should be treated alike without any discrimination. Now, this is a very interesting concept. Means what? Unlike can be given some special consideration. That is what it means. Unlike can be given some special consideration. Say, for example, we have OBC reservation, we have SC/ST reservation, we have economically weaker section reservation. Why it is being done? Because they are socio-economically backward. So they are not to be put on the same level as the general category. So to bring them forward, to give them adequate opportunity, we have reservation system. Taking it further forward, both aim at establishing equality of legal status, opportunity and justice. So for citizens as well as foreigners, this is available. And by the definition of person, when we say, it can be statutory corporations, companies, registered societies, or any other type of legal person. That is, it's not just about an individual. Even companies, boards, all that will come under this definition. Where equals and unequals are treated differently, Article 14 do not apply. This is what I meant. Where equals and unequals are treated differently, Article 14 does not apply. Means what? OBC, SC/ST, EWS, general category. That is a simple logic. So right to equality, if you actually put, what does it mean? There should be no reservation system at all. Correct. But why are we giving reservation? Because the general category and the reserved category, if you see, they are not alike. There is a lot of differences between them. In socio-economic terms, I'm talking. Article 14 prohibits class legislation. Reasonable classification permitted of persons, objects and transactions by the law. Classification should not be arbitrary, artificial or evasive. It should be intelligible, differential, and there should be a substantial distinction. That means class legislation means you cannot give one set of rules for one people and another set of rules for another people. And even when the reservation system also, if you see, it is intelligible. You understand it, okay, it shouldn't exceed 50% of the seats. 50% if it is for general category, another 50% for the reserved category. Agreed. Beyond that, it shouldn't go. It is understandable. And substantial distinction, differentiation is there. There is a differentiation between OBCs, SC/ST, EWS. All of them don't have the same set of reservation. There is ups and downs in it. Differences in it. It is understandable, it is distinguishable, and intelligible. It makes sense. Clear? Moving ahead. Rule of law, basic structure, Supreme Court. Equality before law is a concept of rule of law by A.V. Dicey. Equality before law is a concept by A.V. Dicey, which talks about what? Absence of arbitrary power. Arbitrary power means you cannot do whatever you feel like doing just because you are the government of India or the government of a state. Equality before the law, that is equal subjection of all citizens to the ordinary law of the land administered by the ordinary law courts. Fine. These two, again, under A.V. Dicey's rule of law, it comes. Agreed. The primacy of the rights of the individual, that is the constitution, is the result of the rights of the individuals defined and enforced by the courts of law rather than the constitution being the source of individual rights. That is A.V. Dicey's concept. In A.V. Dicey's concept, actually, so according to A.V. Dicey, the third point, if you see, the primacy of the rights of the individual, that is the constitution, that is where is rights of the individual comes from where? Constitution. And the constitution itself is result of the rights of the individuals. Constitution is a result of the rights. That is, I gave the rights to the individuals first. From there you got the constitution. That is what it simply means. Defined and enforced by the courts of law. Constitution is result of the individual rights. This is what A.V. Dicey propounded. Indian system varies from this. I get my fundamental rights from the constitution. That is, in Indian system, constitution is the source of individual rights. Getting the point? In our country, constitution is supreme. Getting the point? Why constitution is supreme? Because it is the source of rights of the individual. It is not the parliament, it is not the judiciary, nothing. It is ultimately, constitution is supreme in our country. Getting the point here? Whereas in British system and all, if you see, parliament is supreme. Why? Because basically they don't have a written constitution and it keeps on getting added. New laws as it keeps on getting added. Based on that, individuals' rights will change. And as individuals' rights keeps changing, constitution also keeps evolving. Getting the point? That is why in Britain, like I have told in my earlier classes, you go to Britain and ask somebody, where is your constitution? They will show you one full room filled with papers, documents. Why? With each ruling, with each changes being made, the individual rights have undergone changes, and thus the constitution has also undergone changes. That is why the result of the rights, constitution is ultimately in Britain, is the result of the rights of the individuals. Whereas in India, if you ask an Indian, anybody, for British citizen asks, okay, this is my constitution, where is yours? Show me yours. We can just pull out a book from the back of our pocket and give, this is my constitution. I get my rights from this book. Getting the picture? This is the difference between the two. My rights comes from the constitution. Their rights comes from how the law is getting interpreted each and every time. So ultimately, constitution in Britain and all, if you see, it is a result of the rights of the citizen. Here it is the source. Moving on. Now, when it comes to exceptions, you would have noticed, under exceptions, what do we have? Let us start with president and governor. So, president and governor, if you see, these are the exceptions that they enjoy. That is, first of all, they are not answerable to court for exercise of what? For exercise of power or duties, whatever they do officially. Then, criminal proceedings cannot be initiated against them during their term of office. Arrest or imprisonment is also not possible during their term. Civil proceedings also can be initiated only after the expiry of 2 months' notice. This is the first exception. All right, to this whole equality. Then, what are the other exceptions here? If two reporting of proceedings of Parliament and Legislative Assembly is made, again, no court can call you. Why did you report this? If it is a true proceeding, if you falsified the information, etc., you will be punished. That is different. But otherwise, true proceedings, if you have reported, nobody can question you on that. Then, MP privilege Article 105, MLA privilege Article 194. What is this MP privilege and MLA privilege? Simply means anything said or done or any act committed or omitted inside the parliament cannot be questioned by a court of law. Similarly, anything said or done, any act committed or omitted by an MLA inside the legislative assembly cannot be questioned in a court of law. Article 31C, which we already saw. Laws that are made to implement DPSP under Article 39 cannot be challenged on grounds of violation of Article 14. Clear? Then, foreign sovereigns, ambassadors and diplomats along with UNO and its agencies, they all enjoy what? Diplomatic immunity from civil and criminal proceedings. Any crime also, if it is committed, you can basically send them off. You can basically ask them to leave. They can go to their parent country. Generally, they don't do it because it can spoil the relationships between two countries. Generally, ambassadors, etc., they behave well. But otherwise, in the event it is caught also, they are just packed off. Prohibition of discrimination on certain grounds. Article 15 states that state shall not make any discrimination against any citizen on grounds only of, that is the key word here, only of religion, race, caste, sex, place of birth. You cannot make a discrimination on the basis of this. And this law is again available to whom? Against state as well as private individuals. There were people again where they basically in their private companies were there, where they basically saw that a person is from a particular religion and they basically denied him opportunity to employment. The whole thing blew up into a controversy. I think this was 1 or 2 years ago. So you cannot make such discriminations there based only on this. There are exceptions to this. Women and children, socially and economically backward classes or SC and ST, admission to education institutions by the 93rd Constitutional Amendment except minority education institutions. Means what? Discrimination only on the basis of this I am doing, then it is violative. But if I am doing it on the basis of social and economic backwardness, then it is fine. Then it is fine. It makes sense. Clear? So one such example is the admission of SC/ST children to educational institutions under 93rd Constitutional Amendment. Okay. Exception was provided for this for except in minority educational institutions. That means that law is applicable to all the private as well as public educational institutions except the ones that are run by minorities. Why minorities only this exception is given? Because they are also backward. They have started that education institution to uplift their community. Getting the point here? They are backward, they set up their own community, their own educational institution to protect their culture, their language, their script or whatever it is and to uplift their population. Clear? Moving on. Advancement of economically weaker sections under 103rd Constitutional Amendment. So, for advancement of weaker sections, that is the EWS, economically weaker section, reservation, etc., when you talk about, those are all what? Perfectly fine. That is again a discrimination, but it is positive. Reservation of OBCs in educational institutions by our 93rd Constitutional Amendment Act 2005. Center enacted the Central Educational Institutions Reservation and Admission Act 2006 quota of 27% for OBC in central higher education institutions including IIT and IIM. Supreme Court upheld the amendment and the act. Supreme Court directed the central government to exclude the creamy layer from among OBCs. That is basically this was to bring in reservation for the OBCs in the central educational institutions including IIT and IIM. What is the number? 27%. Supreme Court upheld the amendment and the reservation policy also, but added a thing over there. Creamy layer. Creamy layer simply means cream is what cake you take on the top, you will have cream. Coffee, if you go to a nice coffee shop and all, what they will do, the cream will be there at the top. Correct. Or normal tea if you prepare also, you can see always the cream floating at the top. So cream simply means what is at the top. So among the OBCs who are already well off financially, they will not come under the reservation policy. And creamy layer is what today? Persons holding constitutional posts. President, Prime Minister, etc. Group A, Class 1, Group B, Class 2, public plus private. Means if one of your parent or any or both the parents are into Group A service, Class 1 service or Group B, Class 2 service, etc., be it in public sphere or in private sphere, equivalent post in private sphere, then you are not eligible. Your children won't be eligible for reservation there. I'll put it bluntly to you. Let us say this year, next year, you will apply under OBC. Okay. You are eligible for reservation. You don't come under creamy layer because your parents are normal, doing ordinary jobs, not having that high salary package, anything. Okay. You are eligible for the reservation. You get the reservation, you clear the exam, you get into Group A service. Let us say IAS early or IRS. You got into IRS. You got into the service using OBC reservation because your parents were from very ordinary backgrounds. Now you are an IRS officer. Can your child apply for OBC? No. Why? Because you are in Group A. Getting the point here? So by the moment you enter into the service, you get into Group A service. That is the end of reservation for your next set of generation. Getting the point here? Your son or your daughter will not be eligible for reservation once you crack the service. Game over. Clear? Moving on. Rank of colonel and above, same thing. Military service also, if your rank is not above a certain level, again, your children won't be eligible. Professional doctors, lawyers, engineers, artists, authors, consultants. Trade, business and industry. Agricultural land, vacant land or building in urban areas. Annual income of more than rupees 8 lakhs. These are the criteria. If any one of the criteria is there, generally you are not eligible for OBC reservation. So that you can clearly say professionals like doctors, lawyers, engineers, artists, authors, consultants, all these will come under this category. Again, if you are able to prove no, my salary is very less, come on. How many engineers are out there who are earning very good packages these days of more than 8 lakhs? Very few will be there. So again, if your child, if you are son of an engineer or a doctor, or the salary is less than 6 lakhs, etc., you are able to show, I don't have any property, this is my salary, this is my income, I don't have anything else with me, then generally you should be eligible for it. But again, it's all a matter of debate, we will see. Reservation of EWS in educational institutions. 103rd Constitutional Amendment 2009. 10% reservation to EWS in educational institutions. What is the percentage? 10%. As per 103rd Constitutional Amendment 2009, 10% reservation has to be given in educational institutions for those people who are coming from economically weaker background. And get it clear very clearly. This is generally for those people. EWS scheme is generally for those people who are not covered under any reservation policy of SC, ST, OBC. Clear? Some people ask me, sir, how should I apply? I want to apply for EWS and I also want to apply for OBC. No, dear. You only apply under OBC. If you ask me, for whom is this EWS? EWS is basically for the general category. That is, I know people who just because they are from the upper caste, okay, they are upper caste in the society, but financially they are backward. Father is working as what? Security guard in ATM machine. He is the only breadwinner. Mother is housewife, taking small tuitions here and there. They don't have any other income. They don't have any other property. They are still living on rented accommodation. But because their caste is at the upper level, what happens? Obviously, they don't come under any of these schemes, SC, ST, OBC. Their annual income will be even less than what? 5 lakhs also. Because obviously, come on, a security guard in an ATM machine, how much will they be able to earn? So they are by name, we are from upper caste. But money wise, if you see, they have nothing. So basically, EWS again, if you ask why was it introduced, it was again to give a relief to the general category. Getting the point here? It is basically for the general category, because if your income is low, etc., you have a chance now to claim some reservation under EWS. You belong to SC, ST, OBC, you can normally apply under SC, ST, OBC. Clear? And in OBC again, let us say your income is more than 8 lakh. Then by default, you are under general category. You are no more OBC. Yeah, you can say your caste is OBC, but then you'll be treated just like general category. Clear? Income from all sources should be less than rupees 8 lakhs. That is the similarity here. Similarity with creamy layer of OBC as well as EWS is what? Income should be less than 8 lakhs. If income is more than 8 lakhs, you belong to general category. Can you apply for EWS? No. Income is more than 8 lakhs. Your caste belongs to OBC. Can you apply for OBC reservation? No. Again, I am telling you, next year when you are applying, please be extremely careful with your income certificate, caste certificate, etc. If you are going straight away for the general category, no issues. But if you are planning to apply under EWS or any reservation or even physical handicap or anything, be extremely careful. The whole episode last year, whatever has happened with regard to that female, that is still not died out completely. UPSC will see to it that next year who tries to do any hanky-panky here and there, UPSC will make an example out of it. Clear? So ensure that your documents, everything is pakka. Moving on. Exclusion. Who all are excluded? If you have 5 acres of agricultural land, if you have a residential flat of 1000 square feet, a residential plot of 100 square yards in notified municipalities, that means in urban or semi-urban areas, residential plot of 200 square yards in areas other than notified municipalities, any of this, that means if you own property, so there are people who may not have income, but they have properties here and there. Okay, assets they are having. In such a scenario also, you won't come under the definition of EWS. And again, the law is very clear. Properties of father and mother both will be clubbed. So sometimes people are very intelligent. They will only show father's property. See, my father is not having much property. Mother will be from a very rich khandan. In mother's name, there are n number of properties. So what does the law say? Properties will be clubbed. And then the final value will be taken. If any one of the property fills in this category, means you are not eligible for EWS. Then what is the definition of family? Family means, that is, family income is what is looked into, not the personal income of the individual. Family income. So what will constitute that? Parents plus siblings below the age of 18 plus spouse plus children below 18. That means your father, your mother, okay, then there is you, then you have your brother, sister, and if you are married, that individual plus your children. Parents plus siblings below the age of 18 plus spouse plus children below 18. Your children below 18, your parents plus your siblings below the age of 18. That is considered as family. Above the age of 18, that means they are another adult again. Getting the point here? This is how family income will be calculated, or the definition of family. equality of opportunity in public employment. Article 16. No discrimination can be made only on what? Religion, race, caste, sex, descent, and place of birth or residence. When it comes to what? Matters of public employment. As you will clearly remember, even the Karnataka government as well as the Haryana government tried to pass such laws. That is, the Group C, Group D level jobs within the state will be reserved only for the natives there, the locals there. Supreme Court struck it down. Clear? 4 exceptions are, however, there to this also. Parliament can prescribe residence as a condition for employment. Parliament can do that. Public employment requirement as to Residence Act of 1957. Today it is applicable only to Andhra Pradesh and Telangana because of their backwardness. Reservation of appointments or posts in favor of any backward class that is not adequately represented in state services. This also can be done. You can reserve a particular set of jobs for the backward classes. State is empowered to provide reservations in promotion. Promotion for SCs and STs. That is SCs and STs. Again, there is reservation for them with regard to promotion also. Alright. Unfilled reserved vacancies are not to be clubbed. Unfilled reserved vacancies. That means this year there is no SC candidates were there. So that means it is unfilled. Next year also you will have reservations, correct? Can I club this with last year's reservation with this year? No. Because each year vacancies will vary. So every year, based on the vacancy only, you are supposed to put the reservation. Not that, okay, since last 10 years, no SC candidates have been hired. So every year, let us say 2 vacancies were there for SC. So can I club all that and make, okay, 20 reservations for SC? No, I cannot do that. Because 100 vacancies are there also. In that 100 again, I will have to make the allocation accordingly. General category, EWS, OBC, SC, ST. Each year, based on the vacancies only, I am supposed to be making the reservations. Incumbent of an office related to religious institution should be from that religion. Religious qualification. That means if it is a religious body to manage a particular community, a religious community's affairs. Can I put somebody from another religion? No. There I can place religion as a qualification. State is permitted to make a provision for the reservation of up to 10% of appointments or posts in favor of any economically weaker sections. State can do that. Again, as you can clearly see, basically, as long as the discrimination is based upon socio-economic backwardness, it is okay. No issues. Because if you go back very quickly, you will see here, that is the pattern. Backwardness, 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 the 3 points. Then the next one also, if you see, it is again backwardness. Mandal Commission and aftermath. So, Mandal Commission and aftermath. All right, people. So, Mandal Commission and aftermath. Mandal Commission and aftermath. Now we are going to see the whole evolution process by which the Mandal Commission came into force. Then how did we set the limits of reservation? All of that. So very quickly, 1953, the first backward classes commission was set up under Kaka Kalelkar. 1979, under the Moraji Desai government, backward classes commission was set up under the chairmanship of BP Mandal as per the provisions of Article 340, which was basically to investigate the conditions of socially and economically backward classes. Find out what is the issue, what is the reality of it, how socially and economically backward they are. Then, report was submitted in 1980 where 3,743 castes were identified as socially and economically backward. And this set of the population, they were 52% of the total population, excluding the SC and the ST community. That means apart from the SC and the ST community, there are certain other communities which are backward. Clear? They recommended 27% reservation in government jobs for OBCs, other backward communities. The total reservation amounts to 50%. OBC plus SC plus ST. 1963 Supreme Court ruling, more than 50% reservation in a single year is unconstitutional. Means what? That is, total reservation, whatever you are giving or planning to give, should not exceed 50% for OBC, SCs, STs put together. And this was a ruling given by the Supreme Court in 1963 stating that in a single year, the reservation shouldn't cross more than 50%, as this will be considered as unconstitutional. We will see later how there is a change in this rule also. We'll come to that. 1990, during the VP Singh government, declared 27 reservation for OBCs in government jobs. 1991, the Narasimha Rao introduced two changes. Narasimha Rao government basically introduced two changes. One, preference will be given to the poorer sections among OBCs. Number two, reservation of another 10% of jobs for economically backward sections who are not covered by any existing schemes of reservation. Does that sound very familiar? That is nothing but our EWS, what is currently existing. Getting the point? That means this is not a new idea again. This is something that was floated as early as in 1991 by the Narasimha Rao government, stating that when it comes to OBCs, we will give preference to the most poorest section of OBCs. Okay. But what about those people who are not covered under any reservation scheme? That is, they are not SCs, they are not part of STs, they are not part of OBCs, but they are economically backward. So for such economically backward category, which are not covered by any other reservation schemes, we are going to give a 10% reservation, and that is economically backward section, 10%. 1991 they brought this. But was this successful is the million-dollar question. Was it successful? Let us see. In the Indra Sawhney case of 1992, Supreme Court rejected reservation based on economic criteria and put certain conditions. That is, solely or only on economic criteria's basis, if you are going to give reservation, no, we won't agree with it. That is what Supreme Court said. And put up a few more other things. Creamy layers should be excluded from the beneficiaries of OBC. This we have already seen. No reservation should be given in promotion. If there is any existing ones, it will continue only for 5 years, that is till 1997. That is, in the Indra Sawhney case, Supreme Court basically told we are not going to allow reservations in promotion. Promotion should happen as part, rules should be the same for everybody. Currently, any promotional rules etc. based on reservation policy, if it is there, it will only continue for a maximum of 5 years. That means after 1997, nobody is going to get any promotion based on their reservation. This is what Supreme Court ruled. Number 2. Number 3, total reservation should not exceed 50%. Except under extraordinary circumstances. Carry forward rule is valid but shouldn't break the 50% rule. That is, vacancies may be carried forward, but it shouldn't be more than the 50% vacancies. carry forward rule is valid but shouldn't break 50% rule. What does that mean? That means this year there are 5 vacancies under OBC. It never got filled. Next year there are 3 vacancies. So can I take last year's vacancy and add it up? 5 plus 3, 8. Supreme Court says yes, you can, as long as it does not violate the 50% reservation rule. That is, overall reservation should not cross 50%. Permanent statutory body to examine over inclusion or under inclusion of OBCs. A statutory body should be created just to check out whether OBCs have been included under it correctly or whether there is under inclusion. That is, you included some communities or castes which should not come under OBC, or you have not included those communities or castes which were supposed to be included under OBC. These are the rulings. Now, Supreme Court can give any number of rulings. There is no doubt about it. Question is to what extent the Parliament or the Union government or the state government, state legislative assembly are going to agree with it. For some of them, they agreed. Some of them, they overturned it, nullified it by passing separate laws. We are going to see that now. Number 6, no relaxation in qualifying marks and standards of evaluation in matters of reservation and promotion due to the requirement of maintenance of efficiency in administration under Article 335. Again, that is, marks for promotion, etc. should not be relaxed. There is no such thing. That is, make it purely objective. Same marks for everyone. No relaxation in the marks just because you are from a certain community. This is what Supreme Court ruled. What was the action taken by the government? Number 1, Ramanandan Committee was appointed to identify what? To identify the creamy layer. In 1993, they submitted their report and the report was accepted because that was the first thing, because Supreme Court made it very clear the well-off, the creamy layer of the OBC should not get the reservation benefits. Government agreed with it, so they brought in the Ramanandan Committee. Report was accepted also. Great. Number 2, National Commission for Backward Class was established in 1993. A statutory body, just like how Supreme Court wanted. And by the 102nd Constitutional Amendment Act of 2018, it became a constitutional body. And it was added into Article 338B. By the 77th Constitutional Amendment Act of 1995, Article 16, reservation in promotion for SC and ST that are not adequately represented. Means what? Basically, Supreme Court ruled that you cannot put any reservation policy for promotion. If at all you are having any ongoing policy, its maximum validity is till 1997. Correct? Government overturned it. Or basically, Parliament overturned it. How? Through the 77th Constitutional Amendment. Reservation in promotion for SC and ST communities that are not adequately represented. It is that reality, because if you actually say reservation policy has to be taken out, etc. First of all, let us see how many people have got the benefit of this reservation policy. How well the SC, ST or the OBC communities are literally represented, be it at all the levels of government, be it in highly professional jobs, what or admissions to IIT, NIT, IIM, All India Institute of Medical Science and any other government colleges or universities, it's abysmally low even today. So, if the communities are not adequately represented, government has a provision for what? Promoting them through reservation. Clear? The 85th Constitutional Amendment Act, consequential seniority with retrospective effect from 1995. That is, along with reservation, they will also look into what? Your seniority also. And this started to take effect from 1995 onwards. They started looking into, because why 1995? That is when the Constitutional Amendment Act was brought in place. Seniority with, along with that, reservation also. Ruling with regard to backlog vacancies was nullified by the 81st Amendment Act of 2000. That is in 2000. What was the ruling with regard to backlog vacancies? Backlog vacancies can be added up as long as it does not break the 50% reservation rule. This is what Supreme Court told. Government nullified that also. Means unfilled reserve vacancies to be considered as a separate class. This ended up 50% ceiling on reservation in backlog vacancies. What does that mean? Previous year's backlogs are there. I'll put it as a separate class. This year's vacancy also I will put. But even if I am keeping the backlog of the previous years and I'm admitting people into it, even if that breaks the 50% vacancy, it is not null. It is not void. It is proper only. Why did the government do that? Simple reason, underrepresentation. So if a particular community for years together they have remained underrepresented, and let us say suddenly in one fine year, more and more people are coming in, what will you do? You will start filling the backlog vacancies also. What if it breaks the 50% reservation rule? No issues. Simply put, 50% reservation rule will not apply to backlog vacancies. That is the idea here. Moving on. 76th Amendment Act of 1994 has placed the TN Reservation Act of 1993 in the 9th schedule to protect it from judicial review, as it provided for 69% of reservation. Now, this is a topic that needs to be discussed in detail, if not separately. But as of now, this is the thing. In Tamil Nadu, basically, 69% reservation is there. There was a whole process to it. You can read it in the internet also if you want to. There's a whole process to it. And it has been placed under 9th schedule. That means it is not going to be reviewed by the judiciary under Article 13. 1994 it is. This matter is actually, if you ask me, it is still pending before the Supreme Court. Because there is another reservation that is going to be, another reservation issue that is going to be taken up. Alright, this we can deal with it separately. But for now, just understand that this also, if you actually see, has broken, the 50% reservation rule has been broken by the Tamil Nadu State Legislative Assembly. And to protect it from judicial review, they have placed it under the 9th schedule. 82nd Amendment Act to nullify the ruling of Supreme Court in Promotion Article 335, relaxation for SC/ST in matters of promotion. Means what? Marks also can be reduced. It is not just the reservation based on your community alone. If you are from a particular community, the marks or the cutoff that is required for SC/ST candidates in matters of promotion has been relaxed. Clear, people? Reservation for EWS in public employment, introduced by the 103rd Constitutional Amendment Act of 2019. 10% reservation for EWS in civil posts and services in the Government of India. Scientific and technical posts are exempted from the purview of this reservation, especially if it is above the lower grade in Group A services classified as scientific or technical. That is, this particular clause does not apply for these two cases. Other than that, it applies everywhere. Post should be for conducting, organizing, directing, guiding research. Clear, people? So just understand it, just read it. Not so important also, just understand the exceptions there. Moving on. Abolition of untouchability comes under Article 17. And yes, what is the most important thing here? It is a punishable offense. 1976, the Untouchability Offences Act 1955 was renamed as Protection of Civil Rights Act 1955. Interestingly, untouchability is not defined anywhere in the Constitution. Untouchability, when we say, it is not that, okay, don't touch me. No, it is basically those practices which tantamounts to untouchability. Like, oh, my child will not sit with your child. Why? You are from lower caste, I am from upper caste. That is a practice of untouchability right there. or not allowing people to draw water from a well, public well, meant for the entire public. I can say somebody who comes to my home that they want to use, I can say, no, you cannot use my well. That is it's inside my private property. But a public well meant for public consumption, the people are telling, no, 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 you're from lower caste. You cannot come and take the water from here. That is again untouchability. Mysore High Court, the subject matter of Article 17 is not untouchability in the literal or grammatical sense, but the practice as it had developed historically in the country. Getting the point? In one point of time in Kerala and all, how the this practice was done was, let us say if I'm from upper caste, there will be a fellow who will be walking ahead of me, like my servant or somebody, my aide. So he will keep shouting that, move away, we are coming, he will announce it. Lower caste people are supposed to hide themselves behind trees or bushes. Why? Because if an upper caste looks at a lower caste, then upper caste will have to go and take bath. Because looking at the lower caste itself was considered to be polluting. Getting the point here? The state of Kerala has come far from all of that. That is from extreme form of worst caste oppression. Today the state is considered to be a role model when it comes to many aspects of governance and administration. But just to put it in perspective to you, this is how in each and every state, that is even today in some parts of, let us say, states of UP, Bihar, etc., lower caste people are not allowed to ride on top of horses during wedding. They break the horse's leg and they insult the groom as well as their family. Those such things keeps getting reported in our newspapers. Clear? Moving ahead. It refers to the social disabilities imposed on certain classes of persons by reason of their birth in certain castes. That is, socially you are ostracizing somebody, telling that, oh, this fellow is bad. Is it based on their karma? Is it based on their conduct? No. It is solely based on their caste or where they were born, etc. It does not cover social boycott or the exclusion of few individuals from religious services. Social boycott is different. Social boycott means what? You are not going to give rice, or you are not going to sell anything to a person who has killed somebody. An entire village decides we are not going to support him because he killed somebody. That is social boycott. That is okay. Or you are not allowing somebody to handle the affairs of a religious body. Why? Because that person is from a different religion. Both the faith are different. Clear? So that is also not untouchability. People's Union for Democratic Rights in 1982 Supreme Court basically ruled that Article 17 is available against private individuals as well, and it is the constitutional obligation of the state to ensure that such things doesn't happen. That is, untouchability as a practice is not entertained in the country. Clear, people? Moving on. Abolition of titles comes under Article 18. Prohibits the state from conferring any title except military or academic on anybody, whether citizen or foreigner. That is, prohibits the state from giving any title. As long as it is military or academic, it is fine. Military means captain, major, colonel. Academic, doctor. IAS, IPS. These are not titles given to you. Those are your educational qualifications. Very few aspirants also know about this actually. Once you crack the service, you complete your training, you get the president's certificate, etc., you become an IAS officer. Agreed. But what are those IAS letters in front of your name? Your educational qualification it is. It clearly shows you cracked the exam. Nobody will go and ask an IAS officer, right? Did you clear prelims? Why? IAS is there in front of the name. That clearly shows the person has cracked the service, underwent training. Clear? Prohibits citizen of India from accepting any title from any foreign state. No citizen or foreigner holding office of profit or trust under the state cannot accept any title, emoluments, present or office from any foreign state without the consent of the president. Honorary titles are different. Say for example, sometimes celebrities gets it from France, from Brazil, from other different countries. They may give as honorary titles in recognition of their work. So these honorary titles are just meant for just that, for that moment, for that ceremony only. It's more ceremonial than it is like a proper designation or something. Ceremonial, that is, we are recognizing your work. We are very happy for the contributions you made to Indian cinema or to world cinema. We are happy for the entertainment that you gave us. So we want to reward you. We want to recognize your hard work that you have been doing for the last 20-25 years. So we are giving you this award. That's it. It's more of an award rather than a title. Clear? Any other form of this title, present, etc., when you are going to do, you will have to take whom? The consent of the president. Hereditary titles of nobility like Maharaja, Raj Bahadur, Rai Bahadur, Rai Sahib, Dewan Bahadur, etc., which were conferred by colonial states, are banned by Article 18. Balaji Raghavan case in 1995, Supreme Court upheld the constitutional validity of national awards. National awards, that is, initially national awards were actually, today it is national award, but initially it was called Bharat Award. So Bharat Award means actors who got the national award earlier, they were actually, Bharat was added in front of their names. Alright, actually you're not supposed to add, but unofficially at least it was added. And actors used to call themselves as Bharat, then the actor's name. So Bharat, when you put up in front of your name, automatically it means what? You have received the national award. That is what it used to mean. Only within the movie circle, actors used to do that. Later, it was the Bharat terminology itself was dropped. It only had one meaning, national award. That's it. So nobody will say national award Amitabh Bachchan. No, that is not said. We basically say, well, okay, 2024 or 2023, Amitabh Bachchan has got the national award for best actor. Finished. You don't add any names in front of it. Clear? These awards do not amount to titles. Supreme Court clearly ruled. They are not titles to be put either as suffix or as prefix. You cannot put it before your name or even after your name. They should not be used as suffixes or prefixes. National awards were instituted in 1954. Morarji Desai government discontinued them in 1977. This was reinstated by Indira Gandhi in 1980. Padma awards are awarded every year on the Republic Day, and on some years there were interruptions like 78, 79, 93 to 97. There were interruptions. Padma awards also, if you see, nobody will call Padma award. They don't use Padma. Let us say, I think Priyanka Chopra is also one. Padma, Priyanka Chopra, nobody will say. So they may put it up like this: Padma awardee Priyanka Chopra. Means she has received the Padma award. That's all that it means. Again, she cannot use it as a suffix or a prefix in front of her name. The total amount of Padma awards should not exceed 120, excluding posthumous awards and awards given to foreigners, NRIs, OCIs. Bharat Ratna restricted to 3 per year. Clear, people? This is the total idea. All right. Taking it further forward. Next, right to freedom. And you have under right to freedom, protection of 6 rights. Article 19 guarantees right to freedom of speech and expression, assemble peacefully and without arms, form associations or unions, or cooperative societies. And again, there is a small change to that by the 97th Constitutional Amendment Act 2011. We'll see that. Move freely throughout the territory of India, reside and settle in any part of the territory of India, practice any profession, or to carry on any occupation, trade, or business. These are the rights. To speak, assemble peacefully. Once again, speak, assemble peacefully, form association, reside and settle, move freely anywhere, then reside and settle, then finally any profession or occupation. 6 rights under Article 19. All right. Acquire, hold, and dispose of property deleted by 44th Constitutional Amendment Act. It is no more a fundamental right, it's only a legal right. Moving on. Protected against only state action and not private individuals. That means private individuals can put a stop. Just because a clause is there, reside and settle anywhere in India, does not mean that somebody can come and settle inside my home. Getting the point? That is where it is said that it is protected against only state, not private individuals. Available to citizens and shareholders of a company, not to aliens. We saw that 15, 16, 19, 29, 30 are not available to aliens. Not foreigners or companies or corporations. Reasonable restrictions are mentioned in Article 19 itself. So let us start looking at it. Freedom of speech and expression. Basically what? I can air my views, opinions, belief and conviction. Whatever I think, I feel, I want to say, I can say. Either in mouth, writing, printing, picturing or in any other manner. In that any other manner, what will also come? Social media will also come under it. Supreme Court basically said that there should be freedom of circulation, that is to propagate one's views, freedom of the press, freedom of commercial advertisement, right against tapping of telephonic conversation. All of these are part of freedom of speech and expression. Propagate one's views, freedom of the press, then with advertisements, and then my phone should not get tapped. Taking it further forward, right to telecast, government has no monopoly on electronic media. Right against bandh called by a political party, just because a political party calls a bandh doesn't mean that I have to listen to them. I can still go out. Right to know about government activities, freedom of silence, right against imposition of pre-censorship on a newspaper, right to demonstration of picketing but not right to strike. I can do demonstration. I can go and stop someone, but not right to strike. Getting the point here. Moving on. Right to fly the national flag, right of voters to know the antecedents of the candidates contesting election. Antecedents means the history, the past, how many criminal cases are there, how many assets has been made, all of that. Right to choose the medium of instruction at the stage of primary school, right to express gender identity, right to reply, that is the right to answer a criticism. Right to post information or videos on the internet or social media, right of filmmakers to exhibit their films, right to access to the internet, that is right to access to information through the internet also comes under this. Getting the point here. So it is a very broad right in all sense of its words. That is, Supreme Court has kept on interpreting it to the point where today it's a very broad thing. So whenever the internet gets blocked, etc., especially in Jammu and Kashmir and all, Supreme Court has intervened. All right. Taking it further forward, grounds of restriction. So the right to freedom of speech and expression, we know any fundamental right is not absolute. It is only qualified. So what are the restrictions on it? Grounds of restriction, sovereignty and integrity of India. As per 16th Amendment Act of 1963. If it will affect the security of the state or affect the friendly relations with a foreign state, again, added by First Amendment Act of 1951. Public order, again added by First Amendment Act of 1951. Incitement to an offense, added by First Amendment Act of 1951. Incitement means what? Triggering the people with your speech and expression where people will go and commit a crime. Decency or morality, on contempt of court or defamation. On any of these grounds, it can be restricted. Court or the government can put restrictions on your freedom of speech and expression. Freedom of assembly. Anybody can assemble anywhere peacefully and without arms. Right to hold public meetings, demonstrations and take out processions. This freedom can be exercised only on public land. That too peacefully and unarmed. does not protect violent, disorderly, riotous assemblies, breach of public peace, or involves arms. That is where cops basically. Some of you are going to end up as IPS officers. This will be your classic nightmare. Because this is all on a regular basis, this keeps happening in our country. People will take out a religious procession, religion, and another set of people from another religious group will not like it. There will be issues, then it will snowball into a riot. Once it becomes a riot, it's a headache. Because depending upon what is your religion and what is the religion of the victims, either you will get transferred or maybe you will even get suspended. Or you can be in the limelight for all the wrong reasons. It's never ever easy. But anyway, we will worry about that once you clear the service. Does not include the right to strike. Section 144 of CRPC and Section 141 of IPC, unlawful assembly. 144 of CRPC, 144, Section 144 has been declared. Generally, that is declared by the collector. It's like a curfew. More than 3 or 4 people are not supposed to move together, assemble together, stand together anywhere. You can walk out. Individually, you may go out. You can go buy your grocery and return back home. But if you form up as a gang, more than 3 or 4 people are ganged up together, cops can come and arrest you. Especially when 144 CRPC is in effect. Clear? So, the 141 CRPC, that is unlawful assembly, under that we can see, resist the execution of law or the legal process, forcible occupation of property, mischief or criminal trespass, forced to do an illegal act, threaten the government, its officials on exercising lawful process. If any of this you are doing as a gang, all of that is illegal. That is, you are not allowing execution. That is, you are not allowing the government servants to do their job. Number 2, you are going and occupying a property which is not yours. Number 3, any other mischief or criminal trespass which is being done together. That is even robbery. Forced to do an illegal act. You are forcing others also to do something illegal, like breaking a police barricade, threaten the government or its official on exercising their powers, directly threatening them. Grounds of restriction, again, sovereignty and integrity of India, which was added by the 16th Amendment Act of 1963, and on the ground of public order, restrictions are placed with regard to right to assembly. Freedom of association, right to form political parties, companies, partnership firms. You can form anything that you want. What is the grounds of restriction for that? Sovereignty and integrity of India, added by the 16th Amendment Act of 1963. Public order, morality, freedom of movement. Public order and morality. These are the grounds on which it can be restricted. Coming to freedom of movement. Move freely throughout the territory of the country. Now this rule again, like I told you, you can move freely throughout anywhere, but certain exceptions are there. India is one unit. This will promote national feeling and not parochialism. The entry of outsiders to tribal areas is restricted to protect the distinctive culture, language, customs and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. That is, like I told you, the Jarawa tribes of Andaman Nicobar Islands, or let us say the particularly vulnerable tribal groups that are staying in Chhattisgarh, Jharkhand, Odisha regions, etc. To protect them, restrictions are placed. Supreme Court, freedom of movement of prostitutes can be restricted on the ground of public health and in the interest of public morals. Again, freedom of movement of prostitutes can be restricted, because this again you must understand, this was in the context of the wide spreading of sexually transmitted diseases. So in that context, Supreme Court has given this ruling. Clear? Then Bombay High Court validated the restrictions on the movement of persons affected by AIDS. The freedom of movement has 2 dimensions. One is internal. Internal means what? You have the right to move anywhere throughout the territory inside India. External, right to move out of the country and right to come back to the country. Go out, maybe for a job or for tourism, whatever, and then to come back. Article 19 protects the first dimension. That is, whenever we say right to move throughout the territory of India, it talks about the internal movement only. What about if I want to go outside? That comes under Article 21, right to life. Because even if I am going out as a tourist, it's for fun, which that is part of life. If I am going for employment, that is also part of life. Comes under Article 21. What are the grounds of restriction? In the interest of general public, protection of the interests of any scheduled tribe. All right, people, with that we come to end of part 1 of fundamental rights. It's a little lengthy chapter. That is the reason we'll be doing it in 2 parts. So stay tuned for the next part. Take care, people.